Part of our commitment to putting Southeast Texas first means getting answers to your legal questions. Here on Wednesdays, we get to ask the judge, and we're joined this afternoon by Judge Randy Shelton at the Jefferson County Courthouse. Judge, good to see you.
Good to see you, Jordan.
Hope you're staying cool in this heat. This week, this week we want to tackle another topic that we often get questions about here at 12 News, and that is juvenile crime. Let's start with a question we hear quite a lot, and that is, who decides whether a teen should be charged as an adult?
The district attorney is one that would really make that decision, and they would decide whether or not to pursue that. There is a hearing, and at the hearing, the judge and not a jury would decide whether or not the child would be transferred over to the criminal district courts.
So who would serve on that hearing panel, if I'm understanding right?
Well, the judge would be that would make the ultimate decision, but the child would be present. The child's parents would be present. The child would have an attorney that who would represent the child, and the district attorney's office would be there as well. Generally, the witnesses for the district attorney come from the juvenile probation department, who really does sort of a lot of the pre-trial work and review of the circumstances. It's a little more extensive than just what the facts of the offense were. It really goes into more detail about the child's background. Some psychological evaluations are performed, education, and history.
Okay. Again, if you're just tuning in, we're talking juvenile crime here with Judge Randy Shelton. This next question, a little bit more specific. Does the adult statute apply in certain types of cases? In other words, are we looking at, aggravated assault or homicide in order for a teen to potentially be tried as an adult?
Yeah. Well, first of all, you can be tried as young as age 14 if the crime is capital murder or a first-degree felony. You can be tried as an adult as early as 15 and 16, of course, if it's any other felony. And at 17, if the offense was committed when the child was 17, then of course he would automatically be tried as an adult anyway.
Okay. This next question of that same vein: could a teen be held in the juvenile system until he or she reaches a certain age and then later be tried as an adult?
Yes. And this happens quite frequently. Used to, the sheriff's department maintain a very specific, isolated area for keeping children who are certified to be tried as an adult who are under 17. Then there were some changes about the rules involving that. So now, even if you're charged with a crime, you're going to stand trial as an adult in an adult district court. But you're under 17. You're going to await your trial in the juvenile detention facility. Now, if you're waiting for trial and you turn 17 in the meantime, you will be transferred from the detention facility over to the jail, and you'll just await your trial along with anyone else 17 or older.
We're going to have to leave it there, Judge, for the time. We really appreciate you delving into this really important topic.
Okay, well, thank you. It's very timely.
Yeah, we get questions a lot. Judge, good to see you. Friends, if you've got questions for the judge, you know where to go. 12newsnow.com/askthejudge. Please submit your questions there.